everyone, welcome back to the channel EduTap. I am Advocate Arshdeep Kaur and I am back with another video on the Securities Contract Regulation Act 1956. We are doing important MCQs and we are covering all the important provisions through MCQs. This year, the securities law has been given 40% weightage, which is huge. I am stressing this again and again. Please start preparing for phase 2 examination from now only, because if you say that you will prepare it after the phase 1 examination, it will not be possible. So you need to start preparing for both the phases from now only. Before I start, I would like to tell you that EduTap is coming up with the live crash course on this SEBI exam for phase 1 and phase 2 both. We will have more than 60 live sessions which will help you in preparing for the examination better. In addition to this, EduTap is also coming up with the test series of both the phases for phase 1 and phase 2. It will be a great help for your revision. We are running a limited time period discount, so if you want to avail it, kindly refer to the link in the description below. So let's begin. This is our second lecture on Securities Contract Regulation Act 1956. If you haven't seen the part 1 video, please refer to it as well. We'll start now. Question number 1. SEBI can issue directions if an inquiry reveals this is necessary in the interest of the investors or to manage the affairs of the stock market intermediaries in a better way. Such directions can be issued too. So if SEBI finds it necessary for two things, what are those two things? In the interest of the investors or to manage the affairs of the stock market intermediaries, then it can issue directions. To whom it can issue the directions? This is the question. Let's read it. The options are to any stock exchange or clearing corporation, to any agency or intermediary associated with the stock exchange, to companies whose securities are listed on the stock exchange, to companies whose securities are proposed to be listed on the stock exchange, right? So the answer is option number E, all of the above. So SEBI can issue directions to all of these, right? When it finds it necessary in the interest of the investors or to manage the affairs of the stock market intermediaries. Understood? SEBI, this is given in section 12A, right? So let's read it. SEBI can issue directions under section 12A if after an inquiry reveals that this is necessary in the interest of investors or to manage the affairs of the stock exchange or clearing corporation or any agency intermediary, right? The directions can be issued to any stock exchange or clearing corporation, this was mentioned, to any agency or intermediary associated with the stock exchange, again mentioned, the companies whose securities are listed, जिनकी list हो गई है, or proposed to be listed on the stock exchange, right? So all of the above, the SEBI can issue directions to all of these. Answer is option E. Let's move on to question number 2. Which of the following is incorrect with regard to the delisting of securities? The securities of a company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. A listed company or any aggrieved investor may file an appeal against the decision of the recognized stock exchange delisting the securities within 15 days. An appeal against the decision of the recognized stock exchange has to be made before SEBI. If appellate authority is satisfied that the company was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 1 month. None of the above. Option C is incorrect. An appeal against the decision of the recognized stock exchange has to be made before SAT, right? So answer is option number C. Rest all the options are factually true. Let's read section 21A. A recognized stock exchange may delist the securities after recording the reasons, only after recording the reasons. For any recognized stock exchange on any of the ground or grounds as may be prescribed under this act, on the grounds that are prescribed under this act and have to record the reasons, provided that the securities of a company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. This was written, this is true. A listed company or an aggrieved investor may file an appeal before the Securities Appellate Tribunal. So before who? The Securities Appellate Tribunal and not the SEBI. The listed company or aggrieved investor may file an appeal before the Securities Appellate Tribunal against the decision of the recognized stock exchange delisting the securities within 15 days. So the time is 15 days from the date of the decision of the recognized stock exchange. 15 days from the date of the decision of the delisting, right? So within 15 days. 15 days from the date of the decision of the recognized stock exchange delisting the securities, and the provisions of section 22B to 22E of this act shall apply as far as may be to such appeals. Provided that the Securities Appellate Tribunal may, if it is satisfied that the company was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 1 month. So, another period of 1 month can be given if it was satisfied, if the SAT is satisfied that the company was prevented by a sufficient cause and that it could not file an appeal within the given period of 15 days. So, further period of how many days can be given? 1 month can be given. Right? So the answer is option number C. It is incorrect. An appeal against the decision of the recognized stock exchange lies before the SAT, that is the Securities Appellate Tribunal, and not the SEBI. Right? Next question, question number 3. Which of the following has power to supersede governing body of a recognized stock exchange? Okay, so what is supersede? Supersede is to take place of something or somebody, right? So this question is, which of the following has the power to supersede governing body of a recognized stock exchange? Let's find out. The answer is option D, central government. So the central government possesses the power to supersede the governing body of a stock exchange, right? Section 11, let's read the explanation. Without prejudice to any other powers vested in the central government under this act, where the central government is of the opinion that the governing body of any recognized stock exchange should be superseded. Where the central government is of the opinion, right? So the central government thinks that it should be superseded, that notwithstanding anything contained in any other law for the time being in force in the central government may serve on the governing body a written notice. So the governing body will be given a written notice by who? The central government. What will this notice have? Notice that the central government is considering the supersession, right? They will send them a notice that the central government is considering the supersession, that the central government is considering the supersession of the governing body for the reasons specified in the notice, and after given an opportunity to the governing body of being heard in the matter. So after the notice is sent, सिर्फ ये बताया जाएगा that the central government is considering it, then the governing body will be given an opportunity of being heard, right? And after giving the opportunity of the governing body to be heard in the matter, it may by notification in the official gazette declare the governing body of such stock exchange to be superseded. If the central government still feels after even giving them the opportunity of being heard that it has to be superseded, then it will do so by a notification in the official gazette, and may appoint any person or persons to exercise and perform all the powers and duties of governing body, right? So they will appoint a person or persons that will now carry out the operations and the duties of that governing body, right? And where more persons than one are appointed, may appoint one of such persons to be chairman and another to be vice chairman thereof. And if they are appointing more than one person, then one person will be the chairman and another person will be the vice chairman. They will decide among themselves and they will appoint a chairman and a vice chairman thereof, right? On the publication of notification in the official gazette under subsection 1, the following consequences shall ensue, namely. So what will happen after the governing body has been superseded? Now let's read it. The member of the governing body which has been superseded shall, as from the date of the notification of the supersession, cease to hold office as such members. So the members will cease to hold the office from such day as the notification specifies, right? Second, the person or persons appointed under subsection 1 may exercise and perform all the powers and duties of the governing body which has been superseded. So the persons who are appointed now, they will perform all the powers and the duties of the governing body. Third, all such property of the recognized stock exchange as the person or persons appoint under subsection 1 may by ordering in writing specify in this behalf as may be necessary for the purpose of enabling him, only for the purpose of enabling in the business, right? Them to carry on the business of the stock exchange shall vest in such person or person. So now the property that will vest in the person or persons who have been appointed only for the purpose of enabling him to carry on the business. right? So now we know that what will happen after it. So now we know what will happen after it is superseded, and who has the power to supersede it? The central government, right? So, which of the following has the power to supersede the governing body of a recognized stock exchange? We have read it. Answer is the central government, and this is given in section 11 of the Act. Let's move on to question number 4. Contracts and derivative shall be legal and valid if such contracts are. When the contracts and derivative will be legal, traded on a recognized stock exchange, settled on the clearing house of the recognized stock exchange, parties and terms must be as the central government may specify. The answer is all of the above. All of these are valid. All of these are true. Section 18A, let's read it first. Notwithstanding anything contained in any other law for the time being in force, contracts in derivative shall be legal and valid if such contracts are traded on a recognized stock exchange. If they are traded on a recognized stock exchange, they are legal and valid. Settled on the clearing house of the recognized stock exchange or in accordance with the rules and bylaws of such stock exchange. Between such parties, if they are between such parties and on such terms as the central government may by notification in the official gazette specify. So they are in accordance with the notification that the central government has specified, right? Between such parties and on such terms. So that is why it was E, all of the above. So contracts and derivatives shall be legal and valid if the contracts are all of these. Question number 5. Which section of Securities Contract Regulation Act 1956 deals in right of appeal against the refusal of stock exchange to list securities of public companies? The answer is B, section 22. Section 22 provides for the right of the appeal against the refusal of stock exchange to list securities of public companies, right? So the answer is option B, section 22. And where does such an appeal lie? It lies before the central government, right? Please note that this lies before the central government, right? Let's read it again. Which section of the Securities Contract Regulation Act 1956 deals in right to appeal against the refusal of the stock exchange to list securities of public companies? Section 22. And where does the appeal lie? Before the central government, right? Now we can move on to question number 6. To which institute central government can delegate all powers conferred on it under Securities Contract Regulation Act 1956. So the central government can delegate its power to which of the following? The answer is RBI and SEBI. Option E, B or C. Section 29A, the central government may by order publish in the official gazette direct that the powers except the powers under section 30. Except the powers under section 30 means section 30 is an exception to section 29A. Exercised by it under any provision of this act shall, in relation to such matters and subject to such conditions, if any, as may be prescribed in the order, be exercisable also by the SEBI, that is Securities and Exchange Board of India, or the RBI, Reserve Bank of India, constituted under section 3 of the Reserve Bank of India. So what it says is that the central government can delegate its power to the SEBI and to the RBI, all the powers. That power which is mentioned in section 30, that cannot be delegated. What is that power? It is the power of the central government to make rules. That power cannot be delegated, but all the other powers can, and to whom? The SEBI and the RBI, right? So the answer was option E, SEBI and RBI, both B and C. Question number 7. Every recognized stock exchange and every member thereof shall maintain and preserve for such periods not exceeding -years such books of accounts and other documents as the central government, after consultation with the stock exchange concerned, may prescribe in the interest of the trade or in the public interest. They will maintain these books for how much period? Not exceeding 5 years. Right? Answer is option number E, not exceeding 5 years. Let's read it. Section 6. Section 6 of the Securities Contract Regulation Act, power of the central government to call for periodical returns or direct inquiries to be made. Every recognized stock exchange shall furnish to the Securities and Exchange Board of India such periodical returns relating to its affairs as may be prescribed. IC will furnish to the SEBI periodical returns relating to its affairs as may be prescribed, right? Second, every recognized stock exchange and every member thereof shall maintain and preserve for such periods not exceeding 5 years. For such periods not exceeding 5 years, such books of accounts and other documents as the central government, after consultation with the exchange board concerned, may prescribe in the interest of the trade or in public interest, and such books of accounts and other documents shall be subject to inspection at all reasonable time by the Securities and Exchange Board of India, and they will be subjected to inspections, right? So the answer is 5 years. Option E, 5 years. They have to maintain and preserve the accounts for how much time? 5 years, right? Question number 8. RSE can make rules in which of the following matters? So a recognized stock exchange can make rules in which of the following matters? The regulation of voting rights in respect of any matter placed before the stock exchange at any meeting, so that such member may be entitled to have one vote only, irrespective of his share of the paid up equity capital of the stock exchange. The restriction on the right of a member to appoint another person as his proxy to attend and vote at a meeting of the stock exchange. The restriction of the voting right to the members only in respect of any matter placed before the stock exchange at any meeting. A and C only, or all of the above? Answer is all of the above. They can make rules in any of these matters, right? Let's read it. A recognized stock exchange may make rules or amend any rules made by it to provide for all or any of the following matters, namely, number 1, the restrictions of voting right to the members only in respect of any matter placed before the stock exchange at any meeting. So the restriction of the voting right. They can make rules regarding the restriction of the voting rights to the members only in the matter before the stock exchange, right? Only in respect of any matter placed before the stock exchange at any meeting. Second, the regulation of voting rights in respect of any matter placed before the stock exchange at any meeting, so that each member may be entitled to have one vote only. So they can make these rules. The regulation of voting right in respect of any matter placed before the stock exchange at any meeting, so that each member may be entitled to one vote only. Each member will be entitled to one vote only, irrespective of a share of the paid up equity capital of the stock exchange, right? So they can make rules regarding this matter as well. The restriction on the right of the member to appoint another person as his proxy to attend and vote at a meeting of stock exchange. So they can restrict the right of proxy as well, right? So the restriction on the right of a member to appoint another person as his proxy to attend and vote at the meeting of the stock exchange. Such incidental, consequential and supplementary matters as may be necessary to give effect to any of the matters specified in clause A, B and C. So all of these are correct. The recognized stock exchange can make rules in all of the following matters. All of this A, B, C, all of the above. Question number 9. Appeal filed to the SAP under section 22A of the Securities Contract Regulation Act 1956 against refusal of the stock exchange to list securities of companies shall be endeavoured to be disposed of within what period from the date of receipt of the appeal? The answer is option D, 6 months. Right? So they will endeavor, they will try hard that it is disposed within 6 months from the date of the receipt of the appeal. Right? Let's read the explanation. It's given in section 22A clause 4. Section 22A clause 4. The appeal filed before the Securities Appellate Tribunal under subsection 1, we have already read subsection 1, shall be dealt with by it as expeditiously as possible, and endeavour shall be made by it to dispose of the appeal finally within 6 months from the date of the receipt of the appeal. Within 6 months, right? Now we can move on to question number 10. Which of the following grants recognition to the stock exchange as per provisions of the Security Contract Regulation Act 1956? We have already read section number 4. So who gives it? Who gives the recognition? The central government. The answer is option C, central government. As per Section 4 of Securities Contract Regulation Act 1956, if the central government is satisfied after making such inquiry as may be necessary in this behalf and after obtaining such further information, it may grant recognition to the stock exchange subject to the conditions imposed upon it. So who gives the recognition to the stock exchange? It is the central government, right? Given in Section 4. Next question, question number 11. Who appoints members of the clearing house to carry out its operations? So who will appoint such members? The answer is option B, clearing corporation itself. So clearing or corporation appoints members of the clearing house. Clearing corporation appoints various members on its behalf which helps it carry out its operations. Right? Now question number 12. A recognized stock exchange may, with the prior approval of the Securities and Exchange Board of India, transfer the duties and functions of a clearing house to a clearing corporation for which of the following purposes? Okay, with the approval of the SEBI. Which of the following purposes? All of these. E, that is the delivery of the securities, the periodical settlement of contracts and differences thereunder, payment of securities. So all of these they can transfer. For all of these purposes they can transfer. Section 8A. A recognized stock exchange may, with the prior approval of the Securities and Exchange Board of India, transfer the duties and functions of the clearing house to a clearing corporation, being a company incorporated under the Companies Act 1956 for the purposes of, what are these purposes? The periodical settlement of contracts and differences thereunder, right? The delivery of the payment of the securities, delivery of and the payment of the securities. Any other matter incidental or connected with such transfer. So a recognized stock exchange with the approval of SEBI can transfer the duties and functions of a clearing house to a clearing corporation for these purposes. What were the purposes? Delivery of the securities, periodical settlement of the contracts and their differences, payment of the securities. Right? So the answer is option E. Question number 13. Section 23JC of Securities Contract Regulation Act 1956 deals with continuance of proceedings. Answer is option D. Continuance of proceedings. Section 23JC. Where a person dies, his legal representative shall be liable to pay any sum which the deceased would have been liable to pay if he had not died, in the like manner and to the same extent as the deceased. So if a person dies, his legal representative will be liable to pay in the same manner as the deceased person if he would not have died, have been paying. Right? So the answer is option D, continuance of proceedings. There is also a proviso to this. The proviso says, provided that in case of any of the penalty payable under the Act, a legal representative shall be liable only in case the penalty has been imposed before the death of the deceased person. So only such penalty that has been imposed before the death of the deceased person, only for that the legal representative will be liable to pay in the same extent and manner as the deceased person would have. Right? So the answer is continuance of proceedings, option D. Question number 14. If a person owns or keeps a place other than that of a recognized stock exchange which is used for the purpose of entering into or performing any contracts, what could be the penalty imposed on him? Imprisonment for a term which may extend to 5 years, imprisonment for a term which may extend to 10 years, fine which may extend to 25 crores, C or D or with both. Answer is B, C or D or with both. Explanation, section 23. Any person who, it is given in subclause E, right? So any person who owns or keeps a place other than that of a recognized stock exchange which is used for the purpose of entering into or performing any contracts in contravention of any of the provisions of this Act. If he owns or keeps any such place which is not an RSE other than RSE, and he performs any contracts in contravention to this Act, and knowingly permits such place to be used for such purpose, shall without prejudice to any award of penalty by adjudicating officer or the Securities and Exchange Board of India under this Act on conviction be punishable with imprisonment for a term which may extend to 10 years. So the punishment is 10 years. Which may extend to 10 years means maximum of 10 years, or with fine which may extend to 25 crore rupees or both. right? So 25 crore rupees is maximum fine, and the maximum imprisonment is 10 years. So the answer is B, imprisonment for a term of 10 years, fine which may extend to 25 years, or both, right? Question number 15. Where the governing body of the recognized stock exchange objects to any bylaws made or amended by the Securities and Exchange Board of India on its own motion, it may within what period of the publication thereof in the Gazette of India apply to the Securities and Exchange Board of India for revision thereof. So the answer is 2 months, option A. If we read section 10.3, then it will be more clear to you that what is this question asking actually. Notwithstanding anything contained in this section where the governing body of a recognized stock exchange objects to any bylaws. So if the governing body of a stock exchange objects to any of the bylaws that has been made by who? The SEBI, right? The SEBI makes the bylaws. And if any of the governing body of the recognized stock exchange objects with such bylaws made or amended under this section by the Securities and Exchange Board of India on its own motion, it may within 2 months. So it may within 2 months. They have been given a time period of 2 months of the publication, 2 months from the publication thereof in the Gazette of India under subsection 2 apply to the Securities and Exchange Board of India for revision thereof. They can ask for revision of such bylaws, and the Securities and Exchange Board of India may, after giving an opportunity to the governing body of the stock exchange to be heard in the matter, after the governing body they can make their point, revise the bylaws so made or amended anywhere any bylaws so made or amended are revised as a result of any action taken under this subsection. The bylaws so revised shall be published and shall become effective as provided in subsection 2. So if they are revised, then again it will be published in the Gazette. So the governing body, it has been given a time of 2 months if they want to raise objections in regard to any of the bylaws made by SEBI, right? 2 months. So let's read the question again. Now it will be clear to you. Where the governing body of a recognized stock exchange objects to any bylaws made or amended by the Securities Exchange Board of India, where they object on its own motion, it may within what period of the publication thereof in the Gazette of the India apply to the Securities and Exchange Board of India for revision thereof. The answer is 2 months. They have been given a time of 2 months. I hope this is clear to you. Contracts and derivatives shall be legal and valid if such contracts are. This is a homework question for you. We have already discussed this question as well. Please comment down the answer below. Contracts and derivatives shall be legal and valid if such contracts are traded on a recognized stock exchange, settled on the clearing house of the recognized stock exchange. Parties and terms must be as the central government may specify, A and B only or all of the above. So kindly comment down the right answer below. So that's all for today. I hope it was a helpful session for you. I will see you in the next video. Thank you.